County grand jury back in session on the Randolph Williams presiding, my daughter Bill Thompson turned off, they had for a long soft prayer. Thank you, may be seated.
Conwell versus Tommy Claver. Conwell versus Tommy Claver. Are you Tommy Claver?
Yes, sir.
Good morning.
Good morning.
This is 24 CR 0057. Mr. Claver, were you born in 1974?
Yes, sir.
Last four digits, social security number 0040.
Yes, sir.
You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation?
Yes, sir.
Is it substantially correct?
Yes, sir.
Counselor, is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
I plead guilty possession of controlled substance, first degree, first offense. You shall receive a sentence of 3 years, probated for 5 years. Defendant shall follow the instructions of a social service clinician during this time period. Receive credit for time served. What's the courthouse estimate? $155. You need some time to pay that.
Yes, sir.
Pay it $30 a month, first payment 30 days from today.
Yes,
You
sir.
need to meet with the probation and parole officer.
Yes, sir. Thank you, Your Honor.
And Judge, if I may inquire, will Mr. Claver be released today or?
He's on contempt for how long?
He gives his specific time, he was over students last month, and his student for his PSI. Taking into custody of PSI credits.
I'll let him out today.
Thank you, Judge.
Thank you.
Luther D. Connor. Conwell versus Luther D. Connor, 24 CR 0064 and 0065. Are you Luther D. Connor?
Yes, sir.
Good morning, Mr. Connor.
Good morning.
Were you born in 2002?
Yes, sir.
Last four digits social security number 0424.
Yes, sir.
You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation?
Yes, sir.
Is it substantially correct?
Yes, sir.
Okay, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
Or plead guilty in indictment number 24 CR 0064, possession of controlled substance first degree, you shall receive 3 years. Under indictment number 24 CR 0065, possession of controlled substance first degree, you shall receive 3 years. Upon pleading guilty under 24 CR 0065, possession of a handgun by convicted felon, you shall receive 5 years. The 3 years sentence and the 5 year sentence shall run consecutively for a term of 8 years. The 3 year sentence is 64 and the 8 years in indictment 20 shall run currently for a total of 8 years. Serve 180 days in jail with a balance probated to 5 years supervised. He shall receive, he should begin serving 180 days upon entry of plea and shall have no credit for any time prior to the entry of the plea. How many days does he have in today?
Judge, I believe it would be about 30 days. The 6 months was to begin upon the entry of plea, which will have been last rule day. So
Okay.
he's got,
He shall enter and complete specially plea. So I will assign an order when it's an appropriate time for him to be interviewed for a specialty plea.
yes, Your Honor.
You just need to, whoever your successor is needs to calendar that, okay?
Yes, Judge.
Okay, thank you.
And I will, Judge, I'll figure up the days and I'll let your office know when he needs to be released.
That'll be fine. Well, he needs to be signed up for specialty plea
Yes,
before he gets
yes,
released. And
yes.
then I want it done, set it up so he can have his orientation and everything, so he gets out. Didn't serve any extra time waiting for that. Okay,
Thank you, sir.
Thank you, Judge.
Conwell versus Dicken. Court cost on us, it'd be, what was the court cost?
$155.
$155, $30 a month. 30 days after he gets out. How do you say your first name?
Chisha,
What?
Chisha,
Chisha Dicken, 24 CR 0075 and 24 CR 0052. We're here today on a pretrial conference. Were you born in 1979?
yes, sir,
Last four digits, social security number.
3253.
What does the Commonwealth have to say?
We just need another negotiation day on this one, Your Honor.
What is the negotiation?
December the 20th at 9.
December 20th at 9 AM negotiation. Next court date is January the 9th.
And Judge, very briefly, with the this procedural posture of this case, I did not file a motion to modify the bond because in one of the cases, Ms. Dicken does not have a bond. I guess, Judge, just to get to the crux of my argument, the second indictment is on a bail jumping charge. Judge, on that day in question, Ms. Dicken actually came to court. She admitted it was late.
I don't know anything about this case here. So let's start out being, what's she charged with
Bail jumping and possession.
before that?
Possession.
Okay, and she failed to appear.
She was late, Judge. It was August 8th. She got here sometime between 12 and 1 o'clock. Criminal court had already dismissed. The civil docket had not began. She drove down from Ohio, complied with all bond conditions pre-trial, and again, Judge, she had called, let the clerk's office know she was running a little bit late. As it was an
What does the
arraignment.
Commonwealth have to say about it?
Your Honor, on the initial case, we had put her in NCIC, and then we've had to, since then, indict her on bail jumping, so we would oppose any type of change of bond.
You can file a motion. I won't use this against you here. Okay, you can file a motion and give it and work with the Commonwealth, see what they said. The fact that she was in CIC and then she didn't show up. Combined makes her high risk, in my opinion, okay?
I'm saying, Judge.
Danielle Naris, this next case.
Daniel, come over here.
Daniel Naris. Commonwealth versus Daniel Naris, 24 CR 0029, 24 CR 0030, 24 CR 0040, 24 CR 0046. Are you Daniel Naris? Good morning. Were you born in 1996?
Yeah.
Last four digits, social security 1043. Okay. What do we have here?
Judge, if I may, I think we're very close.
What does the Commonwealth have to say?
Your Honor, we're ready for a trial date, and there are about 4 cases that are needing to be consolidated.
Why don't you come around here so we can, y'all move to the left a little bit. Move to your left, sir. Okay.
Yes, according to Mr. Stockton, he's wanting a trial date on this case, and there are 4 CR cases that are needing to be consolidated.
Okay. You have any objection to that?
Judge, I don't have an objection. I guess my communication with Mr. Stockton was a little bit different.
Well, you heard what their position is. If it changes, we can change accordingly. Right now, they say they want to consolidate the cases and get a trial date.
My text message was trying to figure out a number on restitution, so those are very different.
What kind of charges are these?
Judge, there's a number of charges, particularly the 2 charges that relate to restitution are 2 burglary charges. There's an additional escape, but
Okay,
and Judge, again, my communications with Mr. Stockton, I think it was on.
here's the thing about it. It's all I've got to go on right now. I'm gonna set a trial date. If he wishes to withdraw that, talk directly to him, but I'm dealing with the people that are here today.
I understand. I understand. I guess, Judge,
December 20th.
December 20th, that's negotiation day. That's-
I bet January the 3rd.
Monroe negotiation day.
Okay.
Sure, he probably stand.
Well, I mean, who has to be there for?
And Judge, I have no objection to the motion to consolidate. My objection would be to the consolidation of all four cases. I don't believe that the two higher number cases relate in any way, shape, or form to the two smaller case numbers. I would concede that the two burglaries have a nexus to them, but talking about a burglary and an escape not related to that underlying charge,
We can't consolidate the escape.
Yeah, that's fine, Your Honor.
I agree.
Thank you, Judge.
Can't do that. Okay. What about the 17th of January?
That's fine, Your Honor.
All of them are consolidated except for the escape.
I said, the two small ones that didn't fall into the.
but that was.
Okay, let me, are you sure all the rest of them can be consolidated except the escape?
Well, I would say the escape and I think that's an assault second or assault third, could be consolidated. They are related in nature.
Okay, well, let me give you till the end of the week to elect.
Okay.
You elect and give notice, the
12.
escape and the assault or the burglaries.
Okay.
Okay.
Sounds good.
Thank you,
Just
Judge.
talking to them.
Stephanie Prader. Conwell versus Stephanie Prader, 24 CR 0092. Are you Stephanie Prader?
Yes, sir.
Were you born in 1999?
Yes, sir.
Last four digits, social security number 2028.
2280.
Motion's been made that there is a plea in this case. Is that correct?
Yes, Your Honor. This is the right docket plea.
Is it a diversion?
Yes, Your Honor.
A motion's been tendered that says that you wish to enter a plea of guilty today. Is that correct?
Yes.
Need to speak up. Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given? Is it
Yes.
freely and voluntarily given, your plea today?
Yes.
Are you the same person named in information number 24 CR 0092?
Yes.
Is your judgment impaired today? Is your judgment impaired? Do you know what's going on here?
Yes.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you, believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter guilty plea. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm gonna go over them and ask you, okay, you have a right not to testify against yourself. No one can make you say anything, right to speak, trial by jury, right to be represented by counsel in your trial, right to confront a prosecutor, and all witnesses called to testify against you. Right to produce evidence, right to all witnesses in favor, right to appeal, right to hire court to lose, and right to fight the Commonwealth, prove beyond a reasonable doubt that you're guilty of the charge against you. And by entering guilty plea, then you give up all those rights. You understand that?
Yes, sir.
I would consider the Commonwealth's recommendation that I may apply a range of sentence provided by law. I do not have to accept the recommendation. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. I have a couple of qualifying questions here. Have you previously been diverted in the last 5 years?
No, sir.
Have you had any felonies in the past 2 years?
No, sir.
Are you currently on probation?
No.
Okay, you understand that if you fully complete the diversion agreement, the charges could be dismissed. And if it's pretrial diversion, you can have your record expunged. Do you understand that?
Yes, sir.
You also understand if you do not fully complete the diversion program, you're brought back in front of the court. The court voids your pretrial diversion, will schedule a sentencing hearing and you'll be a convicted felon. You understand that?
Yes, sir.
Step to your left, please, Mr. Cleverly, but it's the Commonwealth's recommendation.
Judge, upon a plea of guilty of possession of controlled substance in first degree, first offense, namely methamphetamine, the defendant shall receive a sentence of 2 years, pretrial diverted for 4, supervised. The defendant shall be referred to the social service clinician and follow in any and all directions. The defendant agrees and shall obtain gainful employment or do a minimum of 30 hours per week community service. Defendant agrees to have any and all evidence in this case disposed of in a manner consistent with the law of the common.
Is that what you agreed to, young lady?
Yes, sir.
Behind, scoot over there, Mr. Hunley, let her behind the table.
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended? And the information rather as amended?
Yes, sir.
Are you doing so of your own free will?
Yes.
Okay, knowing your constitutional rights explains still your desire to give up those rights, enter a plea of guilty and allow the court to fix your punishment. Is that correct?
Yeah.
Is that your signature on the offer?
Yes, sir.
I'll accept the agreement. What's the court cost in this case?
55.
$155. I'll let you have some time to pay that, pay your first payment of $30 in 30 days, and every 30 days after that, you pay $155 off, okay?
Thank you, Judge.
You'll need to meet with a probation parole officer. What?
I was gonna ask, yeah,
When can you enter your Mr. Probation Officer?
I will be ready to see her Thursday morning at 9:30.
Okay, I'll let her out, Thursday morning at 8 o'clock. Come over here. Well, you gonna take some preliminary information with her? Okay, if you take preliminary information today, I'll let her out today.
thank you, Judge.
Just warn her about her conduct till she comes in and meets with you. Cody Brown. Commonwealth versus Cody Brown, 24CR007. Are you Cody Brown? Good morning. You born in 1994. Last 4 digits, social security number 1023. Represented by Mr. Turner. You're here for pretrial conference.
Yes, sir. We're prepared to enter into a plea agreement to.
Is it diversion or felony plea?
Diversion.
A motion has been tendered that says you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol? You have to speak up just a little bit because we got a voice activated microphone.
No, sir.
Are you doing this freely and voluntarily?
Yes, sir.
Are you the same person I just identified in 24 CR 0070?
Yes, sir.
Is your judgment impaired today? Is your judgment impaired?
No, sir.
Okay, have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you, believe you're fully informed about your case?
Sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. Before I accept the plea, I need to know that you understand those rights. I'm gonna go over them. I'm gonna ask you. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial, but you have the right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses. Call testify. That's your right to produce evidence. Your right to call witnesses in your favor. Your right to appeal this matter to higher court if you lose. Your right to apply the Commonwealth prove the unreasonable doubt to guilty of charge. You understand that by any guilty plea that you give up those rights. I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. If I do not accept the recommendation or decide to do something more harsh, you have the right to withdraw your plea and proceed to trial. You understand that?
So,
I'm gonna ask you some qualifying questions here. Have you previously been diverted in the last 5 years? Have you had any felonies in the last 10 years?
no, sir.
Are you currently on probation?
No, sir.
You understand that if you complete diversion program, charges could be dismissed, pre-trial diverted, you can have your record expunged. You understand that?
Yes, sir.
You understand if you do not complete the diversion, but you be brought back to court, voids that agreement and schedule the hearing and be convicted felon, that could be used against you for a persistent felony offender like the other felonies. You understand that?
Yes, sir.
Step to your left a little bit, Mr. Huntley. What's the Commonwealth's recommendation?
Your Honor, upon a plea of guilty to possession of a controlled substance first degree, namely meth or methamphetamine, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years, supervised. The defendant shall be referred to the social service clinician and follow any and all recommendations. The defendant shall receive credit for time served. The defendant agrees to forfeit a chrome 6-shot 22 revolver to the Kentucky State Police and disposed of in accordance with the forfeiture order. The defendant shall obtain and maintain gainful employment for a minimum of 30 hours per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above docket disposed of in accordance with the Commonwealth of Kentucky law.
Is that what you agreed to, sir?
Sir.
Are you pleading guilty because you did commit the acts charged in the amended indictment?
Yes, sir.
You do so of your own free will?
Sir.
Knowing your constitutional rights is still your desire to proceed with this plea and allow the court to fix your punishment.
Sir.
Is that your signature on the document?
Yes, sir.
I'll accept the agreement, sign a diversion order. You need to meet with the probation parole officer there to get information, okay? James Harold, I understand he's in custody, Tennessee, is that correct?
Yes.
What's the Commonwealth gonna do about it? Y'all got a hold on him down there?
Got old.
Okay. James Maynard. James Maynard.
He's in custody. Y'all bring him over? Yeah. Yeah, I didn't do a transport order.
Okay, we'll just put him on the jail docket then. Michael Richie. Your sentencing. Commonwealth versus Michael Richie. 24 CR 0066. Are you Michael Richie?
Yes, sir.
Good morning.
Morning.
You born in 1973?
Yes, sir.
Last 4 digits, social security number 4878.
Yes, sir.
You're here for sentencing today. You had an opportunity to look at the pre-sentence investigation report done by probation parole.
Yes.
Is it substantially correct?
Yes.
Is there any reasons gentlemen should not be sentenced?
No, Your Honor. I guess the only thing I would note and just note with probation and parole, the change on medication.
Do what?
There's an error on, I think, Mr. Richie was taking medication he's no longer taking, so I just wanted that to be reflected on the PSI.
I'll make your.
Thank you.
On plea of guilty possession of controlled substance, first degree, first offense, defendant should receive a sentence of 2 years probated, 5 years supervised. The 2-year sentence shall run consecutively, Clinton indictment number 22 CR 0015. He shall complete and enter the specialty court. Is he in yet?
Yes, Judge.
Shall receive credit for time served. Defendant agrees that probation in 22 CR 0015 shall be extended for a period of 5 years from the date it was signed. All evidence shall be disposed of. The court costs in this case how much? Need some time to pay that?
Yes.
Okay, pay your first payment of $30, 30 days from today, $30 every 30 days till 155 is taken care of, okay?
Okay.
Make your probation pro officer. Scotty Spear. Scotty Spear. Says on the docket, agree, what does that mean? Conwell versus Scotty Spear, 24 CR 0088. Are you Scotty Spear?
Yes, sir.
Born in 1994.
Yes, sir.
Last 4 digits, social security number 3202. You're here today for the purpose of arraignment, but about to be silent, represented by counsel. The grand jury of Clinton County has returned an indictment charging in possession of the whole substance in first degree, possession of drug paraphernalia, unauthorized use of automobile, possession of a handgun by a convicted felon, and being a persistent felon. You acknowledge the identity of your client receiving that in a way formal reading and arraignment, and your plea not guilty is urged on pretrial motions.
Yes, Your Honor.
Sign a reciprocal discovery order. Commonwealth will provide you with information to help you prepare for trial. The negotiation day is on December the 20th. Next court date's on January the 9th. William Stearns.
Your Honor, I'd like to discuss bond on Mr. Spear.
I'm not gonna make a bond on Mr. Spears at this time because has I'll let you have a bond hearing, but he has a possession of a firearm by a convicted felon, some other serious charges, and he wasn't in custody. Showed up today, and I don't have a report on him yet. So he's moderate, so you can schedule a hearing.
Well, how soon can we do that?
I don't know. I don't know when you'll find your motion.
Well, I'll file it today.
Well, file it and we'll schedule. William Stearns.
He has an active warrant, Judge. He's not been arrested.
And some probation revocation. You want to take a look at NCIC on him?
Sean?
Wesley Stockton. Active warrant on Wesley Stockton. Okay. Thank y'all for coming in on short notice. You solemnly swear or affirm that you conduct your duties as members of the Clinton County Grand Jury, that you will carefully listen to all the evidence that presented to you and take actions you think appropriate. You will protect and defend the Constitution of the Commonwealth of the United States of America. So what we got. Very much. Y'all go down and I'll take you to the Grand Jury. Thank you. Okay, now we are a few minutes away from Marion County. But we have the Clinton County Jail on. We could do 20 minutes or so at Clinton County Jail.
And Judge, I also believe, I know at least Mr. Ethan Thompson is here. He was brought over for specialty court. I don't know how many others were brought over, but we have a plea in his case if the court wanted to take that.
You got trouble in back. If you're gonna bring Ethan Thompson on out. Conwell versus Ethan Thompson. Are you Ethan Thompson?
Yes, sir.
Good morning. We'll hear on 24 CR 0069 for pretrial with warning 2000.
Sir.
Last four digits, social security number 0934.
Yes, sir.
What do you have today, Conwell?
Changing plea, Your Honor, pretrial diversion plea.
A motion's been tendered that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person we just identified in 24 CR 0069?
Yes, sir.
Is your judgment impaired today?
No, sir.
Have you discussed these matters with your attorney and are satisfied with his advice?
Yes, sir.
Have you viewed the evidence Commonwealth has against you, believe you're fully informed about the case?
Yes, sir.
You understand that you do not have to enter a guilty plea today? You have certain rights in the Kentucky and United States Constitution. Before I accept the plea, I need to know that you understand the truth. You have a right not to testify against yourself. No one can make you say anything. Your right to speak trial by jury, your right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses, all testify against you. Right to produce evidence, right to call witnesses in your favor, right to kill us and other high court if you lose, right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge. You understand that when you're guilty plea, they give up those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any standard in the range of sentence provided by the law. In the event I do not accept the recommendation that they give today, you have the right to withdraw your plea and guilty and proceed to trial. You understand that? Now, I'm gonna ask you a couple of qualifying questions. Have you previously been diverted in the last 5 years?
Excuse me.
Have you previously had a pretrial diversion in the last
No, sir.
5 years? Have you had any felony convictions the last 10 years?
No, sir.
Have you had any, are you currently on probation?
No, sir.
You understand if you complete the diversion agreement, the charges will be dismissed pretrial diversion, you have your record expunged. However, if you violate the terms of the pretrial diversion, brought back before the court, avoided, have a pre-sentence investigation report done, and sentence should be a convicted felon that can be used against you in the future. You understand that?
Yes, sir.
You move to your left a little bit, Ms. Gordon Anderson, what's the comments?
Yes, Your Honor. Upon a plea of guilty to wanton endangerment first degree, the defendant shall receive a sentence of 5 years, pretrial diverted for 5 years supervised. The defendant shall enter and complete the Clinton Specialty Court Program. The defendant shall receive credit for time served, and as of the entry of this plea, the defendant has served 140 days in jail. The defendant shall be released from incarceration the morning of drug court orientation. The defendant shall have no contact with the victim or the victim's real property. The defendant shall obtain gainful employment with a minimum of 30 hours of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in accordance with laws of the Commonwealth and the holding agency.
Okay, give me a little background on this.
Your Honor, this was originally an assault second case in a criminal trespass, and it was amended down to endangerment. And it looks like he was outside of a home yelling at the neighbors to wake up. He used a 2x4 made to be a club and went onto the victim's property and started to hit the victim. So that was what the weapon was used to strike the victim.
If I may, Your Honor, the alleged victim in that is Mr. Bobby Hicks. Through the course of discovery, it was presented to the Commonwealth that Mr. Hicks also had a baseball bat. During the altercation, there were no injuries. I will say for Mr. Thompson, he was voted into the specialty court this morning. And I believe that the agreement was discussed with Mr. Hicks and I was given his agreement. I know there was a district court.
Is that correct? Is the victim agreed to this?
I have that, I'm going to go back, yes.
You know what can happen to you if you go on somebody else's property to pick up a two before it comes.
Yes, sir.
They can kill you. Under this stand your ground stuff, so. Glad you didn't get hurt, he didn't get hurt, so I'll go ahead. I'll go ahead and sign the agreement. When's the orientation gonna be?
I think Mr. Cross said Thursday.
Okay, well, I'll let him find out what.
So I'll,
He'll see you.
yeah, whenever,
I'll let you out Thursday morning. For orientation.
thank you, Judge.
Okay. Is that your signature? I gotta go ahead and finish that. I'll accept the agreement. Is that your signature? I'm gonna-
Yes, sir.
Okay. Somebody turn the camera off at the jail. Conwell versus Joey Duval. Somebody turn the camera off. Turn the camera off at the jail. Without probably next. Conwell versus Joey Duval, 24 CR. Zero zero 91, are you Joey Duval? Good morning. Good morning. You born in 1980?
Yes, sir.
Last four digits, social security number 6376, for the purpose of arraignment. The grand jury, Clinton County Attorney indictment charging the plea and laying in police in the first degree. You understand that?
Yes, sir.
Acknowledge the death of the client proceeding indictment, waive formal reading arraignment, enter plea not guilty, reserve all pretrial motions.
Yes, Your Honor.
Okay, the negotiation day is December 20th at 9 a.m., January 9th.
The plea, I believe, Your Honor.
Looks like the negotiation was successful.
It was, Your Honor.
Is this a diversion or a felony?
Felony.
Motion been here says that you wish to include that, is that correct? Are you currently under influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
The same person just identified in 24 CR 0091.
Yes, sir.
Is your judgment impaired?
No, sir.
We discuss this matter with your attorney. Are you satisfied with her advice?
Yes, sir.
We review the evidence Commonwealth has against you.
Yes, sir.
You believe that you have been fully informed about this case.
Yes, sir.
You understand that you do not have to guilty plea today. You have certain rights under the Kentucky United States Constitution. If I can accept it, plea, I need to know that you understand those rights.
Yes, sir. I fully understand.
Well, let me go over with you just in case. Wait, but you might understand something's wrong. Okay, so I'll go over and ask you, okay? You have a right not to testify against yourself. No one can make you say anything, right to speak, trial, but jury, right to represent the counsel, jury, trial, right to another counsel, can all witness, call testify against you. Evidence, right to call witnesses in your favor. Right to appeal this matter to higher court if you lose, or right to party the Commonwealth, reason doubt that you guilty charge against you. Understand that if I am guilty plea, you give up all those rights. You understand that?
Yes, sir. I understand.
Now, I may consider Commonwealth's recommendation when I may play range percentage probable. I don't have to accept any recommendation. Prior to accepting your recommendations in this case, well, this is a pretrial diversion.
No, felony plea, Your Honor.
Felony plea, I'll have a pre-sentence investigation report done by probation parole. And then I'll determine in the event I do not accept, after reviewing that pre-sentence investigation report review. In the event I do not accept the Commonwealth's offer, decide to impose a harsher sentence, I'll choose driving for a trial. Step your left. Ms. Gordon Anderson, what is a Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to wanton endangerment, first degree, 5 counts, and persistent felony offender, second degree, 5 counts, the defendant shall receive a sentence of 9 years on each count to run concurrently for a total of 9 years. Upon a plea of guilty to fleeing or evading police, first degree, a class C felony, the defendant shall receive a sentence of 5 years. The 9-year sentence and the 5-year sentence shall run consecutively for a total of 14 years, probated for 5 years, supervised. The defendant shall be assessed for Clinton Specialty Court, and if he qualifies, he shall enter and complete the Clinton Specialty Court. The defendant shall be released from incarceration the morning of orientation. In the event the defendant does not qualify for Clinton Specialty Court, the defendant shall enter and complete a long-term treatment facility for a minimum of 180 days determined by and scheduled through DPA and agreed upon by the Commonwealth. Probation and Pro shall transport the defendant to the treatment facility the morning of his bed date. The defendant shall receive credit for time served and shall serve 270 days in jail from the date of October 1st, 2024. The defendant shall not be released in drug court or long-term treatment until the service of 270 days incarcerated. Defendant shall obtain gainful employment or do a minimum of 30 hours per week until gainful employment is obtained. The defendant agrees to have any and all evidence in both style case disposed of in accordance with laws of Commonwealth and the holding agency.
Is that what you agreed to?
Yes, sir.
You back over here. Are you pleading guilty because you did commit the act charged in the indictments as amended?
Yes, sir.
You sold your own free will,
Yes, sir.
and your constitutional rights, your desire to receive your plea out of court to fix your punishment.
Yes.
You understand by entering this plea, any future convictions can be enhanced. Persistent offender
Yes, sir.
law. Is that your signature on the motion?
Yes.
I'll accept the plea agreement for the court process case. $155, but since you're gonna be incarcerated, all out, wait till you get out 30 days after you're released from incarceration, pay $30 a month till it's paid, okay?
Okay.
Okay,
And Your Honor, I do want to advise the court, he was assessed by drug court already and was eligible for the program, so.
okay, well, when after he serves his time, I'll do a release order for it after he's oriented, okay?
And Your Honor, I think we did the plea paperwork under the 24 CR 73, so I don't know if the court wants to consolidate the 24 CR 91 indictment into that case. It was just to reflect the new the change in the law.
Commonwealth agree with that?
I agree.
Okay, enter an order, consolidate.
And are we setting this for a separate sentencing, Your Honor?
Will be next month. January 9th,
January?
pre-sentence investigation board, January 9th.
I was scheduled to come on the page.
Okay. Take that off here, okay, thank you.
Thank you very much, Your Honor.
Yeah.
No, they may be good.
Arnold Bell, let's go back to the jail, turn the Zoom on. Arnold Bell. Camera on, please. Change jail. Hello, Clinton County Jail. Okay, there you go. Conwell versus Arnold Bell. Are you Arnold Bell?
Yes.
We are on 23 CR 0040. Mr. Bell, were you born in 1966?
Yes.
Last four digits, social security number 0067.
Yes.
We are on probation revocation. What does the Commonwealth have to say?
Judge, this is the Commonwealth's third motion to revoke Mr. Bell's probation. He was currently being supervised by joint agreement between Kentucky and Tennessee probation. He received a arrest on October 8th of this year and has not been seen or heard from since and is considered an absconder. In addition, he had a admission of use of methamphetamine on June 17th of this year. And he had previously been convicted of a criminal mischief charge in Clinton County on July of last year.
You want to stipulate?
Mr. Bell, are you still wanting to stipulate?
Yes.
I'll stipulate and impose the sentence.
Yes, Your Honor.
Thank you. Charles Dicken. Charles Dicken. Conwell versus Charles Dicken. Conwell versus Charles Dicken, 24 CR 0043 and 24 CR 0044. Are you Charles Dicken?
Yes, sir.
Good morning, Mr. Dicken.
Morning.
Born in 1961.
Correct.
The last four digits of social security number 5978.
Yes.
You're here today on probation revocation charges. What does the Commonwealth have to say?
Yes, Your Honor. It appears that Mr. Dicken went on supervision in October of this year, and he has a new misdemeanor charge, a DUI, on November the 1st. And that's our basis for revocation.
And Judge, I don't know if Mr. Dicken has been formally arraigned on those charges. I know, I don't think my office has received that case, so I know it's been very infinite in time.
And I don't know, Your Honor. Mr. I haven't seen that. He's been arraigned on it.
Is it misdemeanor DUI?
Yes.
Anything else?
There were several traffic violations. The rear license was not eliminated,
Can you
no
put a pin
registration.
on him so he'll be a state prisoner? We'll see you next month.
Wait, let me see.
And Judge, I will say, even though it's I will note a pending DUI, Mr. Dicken has expressed interest if the court of Commonwealth be inclined to go into the Clinton Specialty Court.
Judge, he's been arraigned and there's a pre-trial, he was arraigned on November 6th, there's a pre-trial for June.
Is the EPA appointed?
It does not show. On court.
Be in court on the 7th,
Um,
January 7th.
Pre-trial is June 7th.
So now you get the 9th.
So we'll be back here on the 9th. Can you put a pin on him? Oh,
If you order an alternative sentence pending,
I'm ordering an
Revocation.
alternatives to pending revocation. Okay, your attorney will be down there to talk to you, Mr. Dicken. So you're gonna be in district court on the 7th, you'll be up here on the 9th. Thank you. Charles Hicks. Charles Hicks. Conwell versus Charles Hicks, 21 CR 0013. Are you Charles Hicks?
Yes, sir.
Morning, Mr. Hicks. Were you born in 1980?
Yes, sir.
Last four digits, social security number 9917.
Yes, sir.
We're on 21 CR 0013, a probation revocation. What does the Commonwealth have to say?
Well, this is a motion to revoke Mr. Hicks's probation. And it looked like it's going to be.
We take that copy down, each copy is up there. We might have a picnic later. Right now. What do you have on Mr. Hicks?
Well, he is on probation for trafficking in a controlled substance. His supervision began in 2021. He has a variety of violations The latest being that he was arrested in Pickett County, Tennessee, and charged with manufacture, sale, and of methamphetamine. He's also charged for a violation of leaving the state without permission on September of 2024. On September, same month. Well, but look,
Judge, if I
on that
may,
same day, he was charged with possession of a firearm in Tennessee.
You want to stipulate?
well, Judge, I think this is a little bit different. I'm not gonna dispute what the Conwell just read, but what was omitted is there was another individual in the vehicle with Mr. Hicks. I have assisted with him trying to get in contact with Pickett County DPA to no avail. He's not even had a chance to really face those charges, much less than the arrest. So, Your Honor,
Capture him back up here. What happened?
He reported to my office when he got released and I watched him.
Well, I'm not ready to revoke him until we have a little bit more information on it. Let's just prepare it. I'm not gonna revoke you, Mr. Hicks, until we know more about it, see if you got it on there. So let's have him appear here on January 9th. I kind of like for him to be available on the 20th for negotiation. That's a deadline to see if we can find out more information where it's in his attorney. So on the 20th, December 20th, negotiation, and then on the 9th, this next court hearing.
thank you, Your Honor. Charles, we'll be able to talk to you.
Yes, sir.
John
Thank-
Luttrell. John Luttrell. Commonwealth versus John Luttrell. I see Wayne County on there right now. Clinton County's gone off for some reason. Let's go to Wayne County. Wayne County,
Yes, this is my guy.
Commonwealth versus Jimmy Bertram. Are you Jimmy Bertram?
Yes, sir.
And you're here on 22 CR 0056. Mr. Bertram, were you born in 1979?
Yes, sir.
Last four digits, social security number 1527.
Yes, sir.
What do you, it's a motion for shock probation.
Judge, that's my motion, and I actually have an email open right now, to send an agreed order to Mr. Stockton.
Is it gonna have a job? Yeah.
Where are you gonna be working, Mr. Bertram?
I'll go back to work for my dad, brother right now until I pick up back to myself. I build houses usually.
I didn't understand.
He's going to work with his dad and brother.
What do your dad and brother do?
Carpet work, we build houses, sir.
Do what?
Build houses.
Houses.
Build houses.
Yes.
Mr. Stockton was okay, was in agreement with the shock as long as he had a job to go to.
Okay, we'll just need to get some kind of statement filed from his father and his brother, that he'll be fully employed. And I want him under a curfew, work, church, doctor for a while. So it's, have your dad to get a hold of probation parole, is that correct?
They'll have to do the order for that.
I'll include that in the language of the order.
Okay, the order will be coming over soon and we'll try to let you out today if we can get.
Well, not with it being shot, it would still have to go, Mr. F. Stockton's order, your signature, go up to DLC, come back, but Judge, I think Mr. Bertram also has some Wayne County
Okay,
charges.
we'll
he
go
needs
ahead
to
and, what's he got in Wayne County?
I've got court tomorrow in Wayne County.
What do you say?
I have court tomorrow in Wayne County over this shock probation hearing too, sir.
Up for shock there, okay, well, we'll just wait, I'll wait for instructions on when we sign a release order, okay?
Yes, Your Honor. I'll be able to talk to you on my way out today, Jimmy.
All right, thank you.
Burchett, Michael Burchett. Conwell versus Michael Burchett, 21 CR 00117. Are you Michael Burchett?
Yes, I am.
Were you born in 1990?
Yes, sir, I was.
4 digits, social security number 7380.
Yes, sir.
21 CR 00117. Motion for shock probation. What do you have, Counselor?
Your Honor, I'm standing in for the motion on Mr. Burchett because the conflict situation arose. I would rest on the motion that was filed. I do believe from looking at Mr. Burchett's record, while I did not represent him originally, I think he would do
What was
well.
he charged with originally?
It was like 5 years trafficking controlled substance first, and then
Move over to the microphone.
it was like trafficking controlled substance first was what he.
Okay, well,
Yeah.
what makes Mr. Burchett a good candidate for shock probation?
Your Honor, he has spent some time in custody now. He knows
Well, I know
exactly.
he's in custody.
Right.
now, So I know he spent some time in custody.
Yes, he understands exactly where he does not want to
I
be.
don't,
and I
understand.
think
You
he-
can't tell me what he understands. I don't know what he understands. I wanna know why he's a good, has he got a job? What's changed his life? I don't
Mr.
know.
Burchett, do you wish to address the court as to this?
He's already been revoked.
Yes. Your Honor, he made some mistakes.
Mr. Burchett, tell me why I should give you shock probation. Tell me what you did, how you messed up, how you ended up there, and how you're gonna change.
Your Honor, I'm gonna change because I've got a 70-year-old mother that needs me out there, and I'm willing to go back to work. I'm willing to take care of her, and I need to be out to take care of my mama. That's the reason why I'm trying to get the shock probation, and I would be willing to go to Kegel's to get a full-time job to pay bills and et cetera. Yes, I did mess up, and I'm very sorry I did that.
Okay, what's the Commonwealth have said?
Your Honor, just after speaking with Mr. Payne, he said that Mr. Burchett was non-compliant whenever he was on probation, and that he was never able to have a home placement that was approved of.
I've been sent 3 home placements while he was on parole, while he's incarcerated in chance of getting parole, and all of them were denied.
And I believe he's also caused some trouble at the jail.
Unsuitable for him to live there. They wasn't accepted.
Where you gonna live, Mr. Burchett?
I have property in my mother's name, Your Honor, and she's wanting me to come and put a building back down there. She don't have room.
Wait. Where are you going to live? I don't care.
With my mother.
What?
With my mother.
Is she willing to accept you there?
Yes, she is.
Okay.
Judge, I had a parole plan to his mother's on 9/17, and she advised me that he could not live with her at this time. On 9/17.
Well, we've got conflicting information here. We'll have probation and parole do an investigation on this thing. I'll take this under advisement. In the meantime, I want some kind of commitment that he does have a job waiting at Kegel's.
Yes, Your Honor.
Okay, and where he's gonna be, and then we're gonna have some. They're saying you weren't compliant, Mr. Burchett, when you were out before. Now, you can say whether you were or you weren't, but I'm telling you, if I let you out on shock probation, you need to live at the foot of the cross. You know what I'm saying?
Yes, Your Honor.
You gotta work, you don't need to be out gomming around, you need to stay at home, except to go to church, work at a doctor, take care of your child or your mother. We'll take a look with your mother and see if that's a placement. If she will not accept it there, you'll need to come up with another place where you can live, okay?
Can I go to a halfway house?
Well, I didn't ask you, I thought you wanted out.
I mean, I don't, I mean,
The
but
whole
that's
way,
the opposite.
I'm trying to get you all the way out.
Okay, can I would I be able to release
know.
today?
Either I shock you out or you stay in jail. I'm not gonna shock you out to a halfway house. Okay, thank you. Will your attorney be in contact with you?
Yes.
Wayne County, do you have anybody else over there?
No, sir.
Well, thank you very much. Is Russell County, Marion County's on there? Thank y'all for being on so properly. We'll get that. Marion County, Commonwealth versus Joseph Wallace for sentencing. Are you Joseph Wallace?
Yes, sir.
Born in 1976.
Yes, sir.
Last 4 digits, social security number 4673.
Yes, sir.
70 in 24 CR 00055 for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Substantially correct.
Yes, sir, I did.
Is there anything in there that's incorrect, sir?
Now, I can see you, sir.
Okay. If Counselor, is any reason this gentleman should not be sentenced?
No, Your Honor.
On a plea of guilty, traffic control substance, first degree methamphetamine, first offense, he shall receive a sentence of 9 years, and 9 years shall run consecutively. Clinton indictment 22 CR 0017. The defendant shall forfeit $1,345 to the Commonwealth dispersed under the order of distribution and the forfeiture order. He agrees to have any other controlled substance or drug paraphernalia destroyed. Understand what the court costs the case.
155.
155. Now, this is to serve, correct?
Yes, Your Honor.
I'm gonna waive the court cost. I'm not gonna charge you court costs. Okay? Thank you very much.
Thank you, Your Honor.
Wayne County, Marion County, we have no one else there. You may be excused. Thank you for your.
Thank you, Your Honor.
Thank you. Pulaski, are you on there yet? Pulaski County? Okay, let's go back. Is Russell County on there? Let's go back to the Clinton County Jail. Clinton County Jail. Okay, Conwell versus John Luttrell. Conwell versus John Luttrell. 24 CR 0076. Are you John Luttrell on there? John Luttrell.
Yes.
John Luttrell?
Yes, sir.
Good. Good morning, Mr. Luttrell. We're on 24 CR 0076. Mr. Luttrell, were you born in 1970?
Yes, sir.
Last 4 digits, social security number 5446.
Yes, sir.
What's the Commonwealth have?
We have a felony plea, Your Honor.
A motion has been tendered, Mr. Luttrell, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes, sir.
Okay. Are you the same person that we just identified in,
Yes, sir.
okay, 24 CR 0076? Have you, is your judgment impaired today? Are you clear about what's going on?
Yes, sir.
Have you discussed this charge with your attorney and are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence Commonwealth has against you? Are you fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution before I accept the plea. I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have rights. You have right to jury. Have to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called against you. You have a right to give evidence, right to call witnesses, if you have cross-examination, no attendance. You have a right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove without a reasonable doubt that you're guilty. You understand, but any of you guilty plea today, you have to give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may plain range of sentence per the law. Prior to sentencing you, I will order a pre-sentence investigation report to be done by probation and parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea, go to trial. You understand that?
Yes, sir.
What is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to failure to comply with sex offender registry first offense, the defendant shall receive a sentence of 1 year probated for 1 year supervised.
Is that what you agree to?
Yes, sir.
If I order a pre-sentence investigation report to be done by probation, parole, and schedule your sentencing on January the 9th. You've agreed to this, knowing your constitutional rights, as I explained to you, is it still your desire to proceed with a guilty plea? What's the court cost in this case?
$155.
You are entering, I'll give you some time after you get out, pay the court costs at $30 a month. You have the agreement there? Is that your signature on there, sir?
Yes, sir.
I'll accept the plea and see you on January the 9th for sentencing. You realize by entering this plea could be used against you in the future, don't you?
Yes, sir.
Okay, take a look at it.
Thank you, Your Honor.
Yeah. Rodney Manis.
Yes, sir.
Conwell versus Rodney Manis, 22 CR 007, 22 CR 00. Both of them have a different number on one of them. Is it true?
I think it's the same case number.
Mr. Manis, were you born in 1970?
Yes, sir.
Ms. Ford did his social security number 3824.
Yes, sir.
Probation revocation was a Commonwealth episode.
Yes, Your Honor, this is our motion for revocation. The basis is failure to make restitution and receiving a misdemeanor conviction. He's got previous other violations too.
And Judge, when we were here last time, I think Mr. Manis had remitted a payment, was a little bit confused on his payment history. I do believe, and he should be prepared to make a payment today if the court would be inclined to.
How much is he owe in restitution? What's Commonwealth?
At the time of our motion, he was behind about $1,600. I believe was that. Yeah. If he'd been making payments like he was directed, he would have, he's behind $1,600 based on his payment schedule.
What's the total amount left?
Well, let's see, the restitution ordered was $21,160 jointly and severally with a co-defendant. And he has only made, at the time of our motion, $4,207 in payments. If he had been making his payments timely, he would have made about $5,800 in payments. There's quite a bit left. I'm not sure about the co-defendant where he's at, but this is our second motion to revoke in this case.
And Judge, if I may, I don't.
Get behind the quote.
I'm not going to dispute the fact of the second filing. As long as I've been here, I think Mr. Manis is, as long as the court's been reviewing and checking on payments, he's been remitting payments.
What's he got to, what can he put in today?
Rodney, can you make a full payment today?
Yes, sir.
How much is that?
$275.
No, it's not worth it to have bring him back up here for $275. He's how far behind? 1,200?
About $1,600. And two, Your Honor, in August, he got a misdemeanor of burglary post-arrest complaint in Pickett County, Tennessee. That was a previous one, I'm sorry. The theft by unlawful taking was October
Well,
the
he's got
first,
to come up with
2021.
money to get his restitution from somewhere.
Well, that's what our situation is, theft in October.
If he'll make an $800 restitution payment, I'll have him withdraw that thing and he needs to start making these regular payments.
You're going to have to come up with a little bit more money.
Okay.
Thank you, Judge.
You know, sign an agreed order when he pays half of it and then you start the regular monthly payments.
Sure.
James McInich. James McIntosh.
Then I get my.
Yeah, Mr. Manis will be back on for review next month if he's still there on January 9th. I don't see Clinton County Jail on there again. You go James McIntosh for arraignment. Conwell versus James McIntosh, 24 CR 0090. Are you James McIntosh?
No.
Where is James McIntosh? I say I need James McIntosh. Yeah, Pulaski County will be with you right directly, okay? Okay, somebody at Clinton County needs to get me to James McIntosh. I'm gonna switch back to Pulaski since they're on there. Pulaski County, turn your microphone on. Colton Randolph. Colton Randolph. Hit your microphone button there, the red button. He says he can't hear me. What? You need to push that red button there. The microphone button. No, the microphone button, your mic's off. Pulaski County. Your mic, can you hear me? Shake your head if you can hear me. Okay, you need to have somebody come in and push the microphone button on the screen. Usually there are a lot of things on the bottom of the screen, and one of them looks like an old-fashioned microphone. You see it down there? It says audio.
Send that. Name that request is a thing.
Can you hear me, Judge?
Now we got you. Now we got you.
Yeah. I had to wait for that thing to go through a process to unmute on its own for some reason. I've never had that.
Oh, thank you so much. Conwell versus Colton Randolph, 4CR 0087. Are you Colton Randolph?
Yes, sir.
You born in 2006? Were you born in 2006, Mr. Randolph?
Yes, sir.
Last four digits of social security number 4446.
Yes, sir.
Here today for the purpose of arraignment. Your public advocate is here representing you. Get behind the podium, wave your hand, hit on the microphone, say hello, say hello.
Hello.
There he is. You have a right to remain silent. Grand jury of Clinton County is returning an indictment charging you with fleeing or evading the police in the first degree, assault in the first degree, wanton endangerment in the first degree, and being a persistent felony offender on 3 counts. Do you understand what the charges are? I'm not asking whether you did or not.
Yes, sir. Yes, sir.
Counselor, do you acknowledge Mr. Randolph's identity, receiving indictment, great formal reading and arraignment, enter plea not guilty, reserving all pretrial motion? Do you do
Yes, I
that?
do. Yes, I
Okay,
do.
I'm signing a reciprocal discovery order. Mr. Randolph and Commonwealth has just handed your attorney the package. with information to help you prepare your defense. You're ordered to be here on December the 20th, the negotiation day at 9 a.m. and January 9th, your next court date. Both of them are conditions to bond. Your attorney will be over to see you, okay?
Is it in person, sir?
We'll be over to see you in person.
Yeah, I'll see you soon.
Okay, so when I go back to court,
Come back, we'll have you over here on December 20th for negotiation. I want you to do a transportation order so Mr. Randolph can be here in person.
Yes, Your Honor.
On the 20th, and the next court day's on the 9th. He was going to, Plea can be here on that day. If not, we can schedule by Zoom, okay?
okay, can I get my lawyer's number? Or no, you said I'll be here to see me, never mind, my fault, sir.
He'll be over there to see what day you gonna see him.
Maybe today.
He's gonna try to stop by and see you today in person, okay?
Okay, thank you, Your Honor. I appreciate you.
Pulaski County, thank y'all are relieved. Thank you for your help.
Thank you, Judge.
Yeah. Okay, let's go back to Clinton County, see if we can proceed there. Clinton County, you turn your radio on there. Clinton County camera, please. Okay, now I want James McIntosh.
Don't have him, Your Honor.
They say he's not in jail there. Does anybody know where he is? Shelton.
Got John Maynard.
Oh, okay, let's go back to John Maynard then. Conwell versus John Maynard, 23 CR 0042. Are you John Maynard?
Yes, sir.
Were you born in 1962?
Yes, sir.
Last four digits of social security number 0138. We're for pretrial conference. What does the Commonwealth have to say?
We just need a negotiation day.
Negotiation day for December the 20th at 9 a.m. Next court appearance is January the 9th. Your attorney will be down to see you, Mr. Leonard, okay?
All right, thank you.
Now let's go to Mickey Shelton. You have Mickey Shelton?
Yes, sir. Give me just a second. I'll get him.
Mr. McIntosh has an active warrant. Y'all will take care of him in NCIC.
Already have. They're supposed to be working.
I'm gonna take a quick break here while I get a hold of Mr. Mickey Shelton.
What fiber was that, Bruce?
Mickey Shelton.
Yes, sir.
This is 20 CR 0084 for probation revocation and 24 CR 0085 for arraignment. Are you Mickey Shelton?
Yes, I am.
Born in 1970.
Yes, sir.
Last four digits of your social security number is 7583.
Yes, sir.
Standing here in court today, you have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with burglary in the first degree, unlawful imprisonment in the first degree, 6 counts, wanton endangerment in the first degree, 6 counts, criminal mischief in the first degree, possession of handgun by convicted felon, possession of a firearm by a convicted felon, persistent felony offender, 16 counts, persistent felony offender, second degree, 1 count, persistent felony, second degree, another count, possession of firearm. You understand what those charges are. I'm not going to ask you if you didn't. Do you understand what the charges are, sir? You understand what the charges are? I'm not asking you if you did it or not, but do you understand what I just read that charged you with?
Yes, I'm charged, yes.
Okay. We will schedule, you entered a plea of not guilty on behalf of the gentleman.
Yes, Your Honor.
Okay, reserving all pretrial motions. We'll set an arraignment, a negotiation. Are y'all ready to negotiate on this case?
Yes, Your Honor, there's a motion for revocation today, and we just want to put it for the negotiation day as well.
Yeah, we'll include it in negotiation December the 20th and be back here on January 9th. What they're gonna do is wrap this probation revocation in with your other negotiation, Mr. Shelton. So I'm not gonna revoke you today until we know more about what's going on there. Your attorney will be down to talk to you, okay?
Yes, sir.
Thank you very much.
See you soon, Mr. Felton.
Now, is there anybody else down there in the Clinton County Jail?
No, sir.
Okay, y'all may be excused.
Thank you, sir.
We're left with the Russell County Jail. We have some kind of technical problem.
They've been texting me. Let me try to call them again.
Okay. Wouldn't it be a complete day if we didn't have at least technical problem in jail?
Getting on. They may, he says that he won't let them in.
That's what. Obviously.
Okay. She's resending the link.
Mr. Huntley, will you go
We
on
need,
Russell County Jail and help with the technology?
we need Parker Boyd, Lindsay Cass, Virginia Katherine, Haley Harbor, and Lori Support. Lori Support. All right, thank you, sir.
Let's go off the record to get there. 24 CR 0078, Conwell, Kentucky versus Nancy Cash, you're represented by attorney, you have right to remain silent. The grand jury of Clinton County has returned an indictment charging you with unlawful transaction with a minor in first degree illegal substance. You understand what the charge is? You accept, you acknowledge the identity of your client, receive indictment. A formal reading and arraignment, your plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
We have a negotiation, thank you. We have a negotiation day on December the 20th, and the next court date on 9th, and both of them are conditioned to your bond. You make arrangements to meet with your attorney and prepare for this. No complaints as far as continuation of bond. Okay.
Thank you, Judge.
Let's go off the record.
Are we good?
I can send somebody over there and get them and bring them back over here if it's necessary.
You should just be able to put it on this and not right before. It'll ask for that. Or if you need to, I give it on the right back. And that isn't where they you just have to be to.
If they are going smooth, they always be a hitch. This would be the earliest we would have finished. And if all the jails would be least likely to have a problem. Russell County, now, if you turn your camera on and microphone, it'll be in good shape. Yeah, thank you.
1 second, Your Honor. We're still getting everybody up here for you all.
Okay, I guess we need Parker Bird, Virginia Katherine, Haley Harbor, and Lissa Poore.
Okay, give me 1 second. I'll have them right up here to you.
Great, thank you.
Your chair, ladies. Yeah.
Okay, let's go back on the record. Conwell, are you Virginia Katherine or Lissa Poore?
Virginia Katherine.
Conwell versus Virginia Katherine, 23 CR 0045. Miss Katherine, were you born in 1985?
Yes.
Last 4 digits, social security number 5809.
Yes.
We're here on a probation revocation. What does the Commonwealth have to say about Virginia Katherine?
Judge, I have limited information. It seems that she was terminated from drug court and failed to complete the SAP program that she had been enrolled in. That's it.
Okay,
Judge, that's the limited information I have.
Miss Katherine, why were you terminated from the drug court?
I had a dirty.
Dirty test?
Yes.
How many of them?
I was supposed to only had 3, but they never did give me a sanction. They just threw me in jail.
Where did the daughter into the drug court sit her street? She left.
They did 3 tests, sent her to treatment, and she left.
Then they turned.
Absconded.
Bad move.
Judge, I guess Miss Katherine is coming before the court today asking another chance at rehabilitation. I will note,
I'm gonna revoke her pretrial diversion and start her time, and then I'll take a look at shock probation. See if she can convince me that she will comply a little bit better in the future. Okay?
Yes, Your Honor.
Set it for sentencing.
Judge, she's not pretrial diversion.
I think it's,
She's probation.
Okay, well, I revoke the probation.
No.
okay. Virginia, I'll be over to talk to you.
Okay.
Thank you, Judge.
Lissa Poore. Are you Lissa Poore?
Yes, I am.
This is 21CR 00131. Were you born in 1982, ma'am?
Yes, I was.
Last four digits, social security number 2675.
Yes.
We're here on a motion for shock probation. What do we have here, counsel?
Yes, Judge, this is my motion. Ms. Poore is a co-defendant or was a co-defendant with Mr. Burchett, who we've already heard from. I think similar to his situation, she went up for parole in September and with default to Officer Payne, I think has been able to find suitable home placement. What I'm coming before the court asking is for Ms. Poore to be shocked out and permitted to either go to a sober living or to be arranged in ARC if she was still qualified. I think that should have to be assessed by Ms. Baker.
I never had a drug issue with her.
Do what?
I never had any dirty drug tests from her.
What does the Conwell have to say?
Just your honor, and I don't know if there was what witness would be on it, but Mr. Stockton had just made note that there had been some trouble at the jail with some hygiene issues and that he was just opposing the shock. So I'm not, other than just that, I don't know, have any other details regarding that note.
And Judge, this is the same as the other one with the approved home placement I've denied. I think 2 or 3 home placements has been denied for her.
What was the original charge?
It looks like trafficking, first degree, first offense.
And Judge, I'll look on the, Kentucky online offender, look up the full website and what I could ascertain is it just a result of her not being able to find suitable home placement, she received a 12-month deferral. Judge, what I'm asking is to try to find something.
Parole board?
Yes.
Well, I'll leave this, I'll hold this in abeyance to see if your social workers or something can work something out that's acceptable. And we need to look into this hygiene situation. I don't know what it is. I really don't want to ask her any questions online because it's public. I think I have more respect for her privacy than that. So
Yes, Your Honor.
your attorney will be over to talk to you, maybe some social workers to see if they can get you some sort of placement. I'll take a look at it then. Okay, Ms. Poore?
Thank you, Judge.
Okay.
Haley Harbor. Conwell versus Haley Harbor. Arraignment on 24CR 0089. Are you Haley Harbor?
Yes.
Born in 2000?
Yes.
Last four digits is social security number 6213.
Yes.
Can you grant you have a right to remain silent? Your attorney's here.
Your Honor, I want to limit my appearance on this new case to, for today's purposes.
Okay, that'd be fine. The grand jury of Clinton County has returned an indictment charging you with tampering with prisoner monitoring advice and escape in second degree. You understand what those charges are, don't you, Ms. Harbor?
Yes.
Can you say something where I can hear you? Hello?
Me? Yes.
No, that's really low. Mr. Croft, you acknowledge the identity of your client, received the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
When are you going to decide whether you're going to be representing this lady or not?
Well, as a word of explanation, Your Honor, Ms. Harbor, I think there's also a motion to revoke. And I had spoken to her when she was in the Overton County Jail. And I recall telling her to contact me when she was released from there. And lo and behold, she's been in Russell County for an extended time. And I've not heard from her. I only learned this morning where she is. So I'm going to ask that the motion to revoke be passed. And I will decide by the negotiation day, if not prior.
Well, is she I probably want her interviewed because if you're, She has been interviewed here for public advocacy, and she is eligible for public advocacy.
I know she has no money. I don't know if her people want to continue to sponsor her or
But
not.
what I'm gonna do is, you file an entry of appearance by close of business tomorrow, if you're gonna represent her in those two cases. If
Can
not,
you, tomorrow's a really, really rough day for me. Can you give me till, say, Wednesday evening?
well, Wednesday, at close of
Thank you.
business, okay? And if you don't represent her, I'll go ahead and sign this, order appointing public advocacy.
If I, and we'll let DPA know.
Y'all, Ms. Harbor, if your people make a deal with Mr. Cross to represent you, he'll be over to see you. He's gonna tell you about close of business on Wednesday. If not, the public advocacy will be over to see you. You're gonna have a negotiation day on December 20th, and your next court appearance is on January the 9th.
Haley, I'll call you today.
Okay.
And they will also move the motion to the vote.
To that same day.
Thank you, God.
The
That's all.
negotiation, hey, the negotiation will be moved to the 20th too, Mr. Hunley. Mr. Hunley?
Yes.
The negotiation on the 20th will include the probation revocation and the newly arraigned. And now we have, Parker Bird. Parker Bird. Commonwealth versus Parker Bird, 24 CR 0077. Are you Parker Bird? Were you born in 1997? Can you hear me, Mr. Bird?
Yes, sir.
Were you born in 1997?
Yes, sir.
Last four digits, social security number 0903.
Yes, sir.
24 CR 0077 for a pretrial conference. What do we have?
Your Honor, Mr. Bird is a co-defendant to Ms. Cash, who was just arraigned. I'd spoken to Mr. Stockton prior to our last settlement conference to pass his to this coming month so that because we knew Ms. Cash was being arraigned today. So,
A negotiation day on December 20th, and the next court appearance is on June 9th. Ms. Cash was arraigned today, is that right?
yes, Your Honor.
Y'all have conflict counsel?
Your Honor, I think, I'm representing Mr. Bird, and according to Ms. Cash this morning, she doesn't have a problem with me representing both of them, so I'll have waivers to put in the file. Mr. Pennington had a conflict because he had represented the juvenile that was involved in the
Yes.
case.
We currently represent the juvenile related case.
Mr. Bird would have to waive too.
Yes, Your Honor, so I want to
Mr.
make
Bird,
sure.
you have no problem, the same attorney representing you and Ms. Cox, is that correct?
Cash.
Cash? Same attorney representing you and Ms. Cash, or you want a separate attorney?
That's fine.
I can't hear you, man.
That's fine.
Okay, it'll be fine. Okay, I'll go ahead and do it. Do we have anybody else in Russell County?
Your Honor, what is Mr. Bird's bond currently set at? All right, thank you.
Okay, thank you very much, Russell County. You have anybody else need to see us, Russell County?
Like, what about a bond adjustment or anything like that? Can we have something else said?
I can't hear you, Mr. Bird.
I'm having trouble finding, my bond, for surety bond. I can't find nobody to sign it. We couldn't have a bond hearing or anything like that, could we? Cause I've been here for 2 years.
When's your attorney gonna be, when you gonna be over?
I'll be there this week, Your Honor.
She's gonna come up and see you next couple of days, and you can discuss that with her, okay?
All right.
Okay, thank you. Russell County, you're released. Does that conclude the criminal docket? Okay, thank you, Russell County, you're released.
All right, you're welcome, Your Honor. Y'all have a
Criminal
good day.
docket. Come back at 1. Let's go off the record. Shelton versus Shelton.
I have an agreed order on that, Your Honor.
Sloan versus Sloan.
Your Honor, we have an agreed order that tender in that case.
Is that a rearage case?
So I didn't even see, is that? No. No.
I just thought it was a 2009 case. Cabinet versus Wireman.
We're renoticing that, Judge. Yeah, they're getting the wage garnish.
Cabinet versus Jones.
Your Honor, in this case, non-custodial parents ordered to pay $216 a month on current and 43 in arrears, and the arrearage amount at this time is $1,185, and we're asking to pay $800 by January the 8th. That's it for the calls.
Wilson versus Thrasher.
That's not child support. I think that's it for us, Judge.
It's not a child support case.
It's a motion for child support that would say not to private parents and problem, not to.
Harrigan and Garland. So I guess that okay, I put on the civil docket. Okay,
Thank you, Judge.
thank y'all very much. Let's go off the record.
Yeah.
to do the whole thing.
Judge, I think that we may need to do a hearing because what I saw on the DRC tape, I watched it. I think that there was a rebuttable presumption.
Well, but that you weren't involved, okay? And council at that time had responsibility to file exceptions, and they didn't. Now, it hasn't been confirmed yet.
Yes,
That's
sir.
not unusual, because this motion that asked us to confirm probably should have been made back then too.
We thought we were gonna reach an agreement on
Well,
that.
I know, we thought, though, I mean, I thought Kentucky's gonna go to a bowl game this year, but it just didn't work out that way. So, I mean, I think that both sides have been remiss. You didn't file exceptions, and you didn't file motions to finalize the thing. I see, though, we're in a situation that there's not gonna be an agreement when you get down to the point where you try to reach an agreement and nobody can tell me what it would take to make this 4-3-3 thing work. What would it take to make that work? And I know she wants one child
One child, Judge.
all the time. He probably wants a child all the time. Okay.
Well, Judge, there are some things I think that could be hashed out, that probably need to be addressed immediately, such as the stepmother refraining from, interfering with his child's medical records. This is a medically fragile child. She has an incurable blood disorder.
Well, okay, here's the thing about it. Why don't y'all go back and see what you can hash out and then what you don't agree on? And I'm gonna limit testimony out here on what you can't agree on.
I've already made this offer to her to simply split the Christmas holiday half and half, set a final hearing.
I don't want a hearing. I want an agreement.
Okay.
Okay, so go back through there and tell me what you can agree on and what you can't agree on. And then if there's enough for a hearing, we'll have a hearing on that. I don't want to go back and reinvent the wheel and get back, because I can tell that neither of these parties are gonna be satisfied with whatever I decide. And we've got all that testimony and we've got the findings, and we'll see what goes. So go back and try to work something out. And if you've got a wicked stepmom situation, which most people believe always happens 100% of the time, if you've got one of those sort of things, just put some status quo stuff. If it's not true, they won't bother them to have a status quo. And if the status quo is in there, you'll have something to hang your hat on also, okay?
One thing I want you to know is in this particular case, there are no issues of drug addiction, alcoholism, domestic violence, or anything
She
of that
was
nature.
just taken off of drug court. She just graduated from drug court.
That's what they were actually now.
Not even the
Wife's
same
name
one.
was actually now.
Well, we got more Ashleys around here than any place I've ever seen.
His wife is a licensed healthcare professional. She's never had a speeding ticket her entire life.
Well,
She's never
then
had
y'all
any
can
type
talk
of-
that out. What she said about whoever you're with now has not impacted me at all, because it's not testimony, okay?
If she's a medical professional.
Okay,
she's
I don't
got
want to hear
statutory
that.
authority.
I don't want to hear that.
She's
Okay, y'all,
got recordings there.
y'all go back there and try to work it out, okay? Thank you. Okay, let's go back to the beginning of the docket. Watkins versus and others versus Babin.
Your Honor, unless somebody's on the video, I think we're missing an attorney. Still missing one. Somebody correct me. They're the third party plaintiffs.
And I spoke with Mr. Johnson this morning and he told me he was sending somebody down in person.
I don't see the replacement Zoom link from you guys.
Yeah. So I think that we expected it to be here. Yes, sir.
Well, we'll just pass over.
Okay.
Yeah. Get to enjoy the life of a general court judge that does not have a family court. Okay, Midland Credit Management versus Upchurch.
Good afternoon, Judge. William Rich on behalf of the plaintiff. We have a motion for summary judgment. Defendant filed an answer, which is just a general denial. We sent written discovery, including requests for admissions that we never got an answer to. Those are now deemed admitted, so we don't believe there's an issue of fact. At this point, we'd ask court to enter summary judgment.
Who do you represent, Mr. Cross?
Prescription Arnie, no opposition. We've been trying to, we made offers of settlement. They're entitled to.
Motion, summary judgment will be granted, and, did you add an order of sale onto it too?
No.
No, there's no, it's an unsecured judgment, Your Honor. There should be a judgment tendered electronically for you to sign.
Okay, that'll be fine.
Mr. Rich, I've got another settlement offer outstanding, so perhaps somebody can get back with me. Thank you.
I'll have them call you, Mr. Cross. Thank you.
Thank you, sir.
Thanks, Judge.
Yes, Thomas Gormley versus. Alexandria Rochelle Pierce. Anybody here on that? Mr. Gibson's here. Miss Perigin is there. Would you knock on the door back there and see if Miss Perigin is? Gormley versus Pierce. Is there anything on that?
Oh, no, Judge, just been back there about 2 minutes.
No, I said Gormley versus Pierce. That's not.
Oh, that's what we're working on. I'm
You are
sorry.
working on it now?
Yes.
Okay. Thought you'd have it settled by now. Mortgage assets management versus unknown spouse, if any. David Cross, you involved in this, Mr. Song?
What is it, Your Honor? Mortgage?
Mortgage
I
assets.
don't believe so. I'm standing in.
Okay, what's the deal here?
They're moving to add 3 parties, Your Honor.
Without objection, so order, they got order.
They
Electronically file
could be
it.
in, it's electronic.
Really under the order, thank you.
Thank you, Judge.
Okay. Will e-file it, okay, thank you. This is Bulavinci versus Bulavinci, is that correct?
Beulah Bank, I struggle with it too. Beulah Bank's with that, it's correct.
I didn't struggle with it, I just got it wrong.
I struggle with it.
Okay, what do we have here? Says that for review.
You put this case on review. We were here before the court last motion day for temporary child support and temporary maintenance. There was an order entered and you wanted to come back and review the issue of temporary maintenance.
Right.
And we noticed him, we had him actually served by the sheriff with the temporary order that you provided.
He was given so many days to respond.
Yes. He was to appear today. The order
Is
specifically
that
said
him that
that.
just walked in there?
No, he is not here. I think he's told her that he's not coming. We have filed a motion for default judgment and set it for the January 9th docket because he has never filed a response.
Is he out of town now or where is he still living?
He works on the road. He hauls those portable barn buildings.
Yeah.
He works in Kentucky and Tennessee. So he was just asking for the temporary maintenance today.
Open the file there. Let me see what you served on him.
I think it was served November 18th.
That's correct.
We had the sheriff to serve the order just because other than the home address, we have none.
$1,000 per month. Temporary child support. And was there maintenance in it too?
Yes, we had requested maintenance and you was gonna review it today.
I know, but the maintenance wasn't in the temporary order.
No, you left it open for today. You had asked for $1,000 a month maintenance.
Ma'am, do you have any other income besides this?
Just the job that she, listed. I think your income is at 2,000 a month gross. She's contract laborer.
Who do you work for?
What's your Happy Valley Barnes?
Same company?
It's a division of it, that, it's like a corporation
I
that has
don't want to get
different.
into that. It sounds like something I don't want to know as far as.
Yeah, it is associated with that business. Not his business, but the same company he hauls for. She works. for.
Kind of the same company. When are you gonna finish this case out?
I have filed, just today, I filed a motion for default and set it for, January 9th. Just a few minutes ago, I filed it, along with her deposition, setting forth all the property issues. He has not filed an answer. I think he was served in late October.
Is he making a house payment now?
As of recently, yes.
That's $2,500 a month.
Yes, Your Honor.
You want the house sold?
We're asking that she have the house and the
Well,
equity.
yeah, well, here's the problem. Can she finance the house? Does she have the ability? I mean, if she's wanting $1,000 child support, which doesn't seem unreasonable, motion to indicate that $1,000 maintenance is not unreasonable. But then on top of that, if you've got a mortgage amount of $250,000, how much equity do they have in it?
We think it's at least 100, maybe
It's gonna be a
more.
$350,000 house, and there's gonna be tax on it and insurance and utilities and things like that. I mean, I don't know.
We've just not had anybody to negotiate with.
Well, I know, but you have to assume that you're not gonna have anybody to negotiate with, so you need to have a game plan on what's gonna happen when he quits paying this mortgage.
Yes, we were gonna ask that she get the house and that he pay it for a period of time. At some point, she's probably going to sell it. The kids really don't want to move right now, so she's gonna.
Well, if he's gonna pay $2,500 a month, plus $1,000, plus $1,000, $4,500 a month, plus insurance, plus taxes, plus, I mean, maybe the $2,500, they're paying the taxes, the insurance,
It is.
escrow. Is that what they're doing?
Mhm.
Well, I'll sign another order and pay $1,000 in maintenance, and then I'll take a look at I think the best thing to do would be to go ahead and sign the default and then ask for a hearing on division of property. Okay,
Okay,
so give me a default judgment to grant her divorce, gives her 1,000 temporary maintenance, 1,000 temporary child support, and then schedule for her next rule day, which would be. I know, but I'm going to sign it at some juncture. How did you notice it? Do you have to notice the default?
I don't, but
I know, but she did.
I was a little concerned with the 60-day thing, because he was served, I think, October 28th. But, I can go ahead and submit.
No, just wait, have him here, just do another temporary motion, the temporary order at 1,000. Okay, but when we come back here tonight, if he has not answered and I enter default on that day, then we will set a hearing on all of it pretty quickly. Because you cannot allow that to dangle out there on whether you can make the house payments and things like that. There's no certainty that he'll make the next house payment.
Right,
Correct?
right. It is in.
So we got it straight now. You're gonna do a supplemental judge. He didn't respond to this last judgment, but the last judgment, temporary order, rather, did not have 1,000 maintenance in it. So I want you to add 1,000 maintenance. Am I correct? It didn't have 1,000.
Correct.
maintenance. It had a child support.
I'll do a supplemental order.
Do a supplemental order and add that. And then in the order say it should be submitted. The motion for a default judgment is going to be heard on the 9th. And as soon thereafter, within 10 days after that, if it's granted, there's going to be a hearing on the property or something like that. Okay.
Okay, our issue is serving him. It's just, I know the sheriff's office has been very helpful, but he's never here. So all I know
Does
to
he get
do,
mail anywhere?
I think that we'll just have it sent
Does he get
to
mail anywhere?
at her house, which he comes and gets periodically. So I guess I'll just send it there this time.
Where does he work?
He works on the road.
Is the location where he picks up the houses, is it here in Clinton County?
I think it's in Wayne County, and then he goes to Whitesburg, Kentucky, and then
Well, I would mail it to him here. I mail one care of that Wayne County
the Wayne County
location.
business.
I
Yeah.
mail everywhere I can. And then give it to the sheriff too, to try to get him here. This is going to develop into a hot mess if we don't watch it.
I know.
Okay, thank you
Your
very
Honor.
much.
I think that's all I have is up to these.
Sure. Smith versus Smith. Is there an attorney on the other side?
Your Honor, we got her served, I think.
Is there an attorney on the other
We've not
side?
heard anything from anyone. Mr. Smith told her she needed to be in court today. That's all we know.
Who served her? Who files? Tell me how many children about?
One.
How old?
What, 16, 17 months?
No proof of service in the file.
I believe they, it would have been last Friday. How do you know she got served? Okay, we'll just have a seat. We'll have to get proof that she's been served.
Yeah, she's served on over 1 second.
Okay.
Yeah. Where does she live?
I think at Duval Valley. Their mother,
How old? The child is how old?
17 months.
What's going on? She's not letting you see the child at all?
I've got the child.
You have a child.
There was an issue until we filed this.
Do what?
There was an issue about him getting the child until we filed this.
So you filed this and she gave the child up?
Yeah.
And when's she gonna get the child back?
Whenever I go back to work or whenever she wants him.
Yeah. Your Honor, let me explain to the court where we were when we filed this and where we are now. Mr. Smith was employed on the road, and until he could get a job here locally, we wanted custody while he was here. I think now he's decided to obtain employment locally, and as soon as possible. He doesn't have it now, but he owns his own home, lives right across the fence.
What's the deal with her? Where's she?
He's just, well, if she's up here, I was going to ask you to give her a drug test. I'll prove to you that. The home's premarital. He's got a good home. He's got other kids, and he's a responsible.
Well, puts me in a really uncomfortable situation, that she will come. I will tell you that, let's schedule her to come on January the 9th, okay, and to show cause why she should not be held in contempt for not being here today, and set the thing for her. Were y'all married?
Sir.
And how's that going? You say there's no marital property to speak of.
Well, the home is non-marital. I don't think they really own anything.
How long were they married? How long were they married?
To be 3 years in March.
Happily married for a year?
3 years.
3 years.
Been married.
Well, 1 out of 3 is not bad.
Last year's been a little rough.
Yeah.
Your Honor, my thought process, if she's not here, is let's get some kind of an order entered to where she's not here, but I feel like Mr. Smith will be fair with her between now and the 9th, and we may even get an agreed
I was
order.
gonna say that his temporary order would just be that he's got temporary custody and her to show cause why she should not be here on the 9th.
Okay.
And if you're willing to allow her some visitation, but it's, I don't know, I can't give you any advice, but sometimes when they don't show up, they get rabbit blood in them, but you
Well-
understand what I'm saying?
Yes. Mhm.
Okay,
I think that,
give me a temporary order and have
I'll-
her show cause why she should not be held in contempt.
go to my office. I'll be right there.
And so there, this is another default situation that you got with her?
No, she's just been served on the 22nd.
Yeah.
Well,
So you served her with the original petition, not just this motion?
correct. It
Signed
was all,
together.
all
Okay.
served together.
That'll be
I'll
fine.
be back with something.
Okay, thank you.
Don't leave my big signature.
Wilson versus what? Wilson versus Thrasher. Okay. Okay, we're down. Your other counsel appeared.
No,
Well, do y'all have a phone number?
they're trying to reach you. I sent a message.
Who does he represent?
He represents one of the defendants in the original action, but he's the third party plaintiff in a third party complaint.
Let's go off the record and just patiently wait. You're mad. Max. Mr. Whitmer, will you, turn your camera on, your microphone?
Yes, Judge.
Yeah. Are you hiking today?
I apologize for my appearance. I was not prepared to be in court today. The
Your
notice.
appearance doesn't bother me. Your absence is what bothers me more than your appearance. Okay. Now, let's see, I guess we got a motion to dismiss here today. Is that right? Second hearing on the motion to dismiss.
I think you've got three motions on behalf of all three third party defendants to dismiss.
Yeah.
And there was an agreed order previously entered between the third party plaintiff and third party defendants.
Could you get behind the microphone?
Sure, I'm sorry. I think you have, let me say that again. I think you have three motions that are very similar motion on behalf of all three third party defendants to dismiss the third party complaint. And then there was an agreed order that was tendered before a previous hearing that the plaintiff lodged an objection to, and which led us back here to renotice our motions to dismiss. So.
Well, let's talk about the plaintiff's objection to the previous order first, okay?
So, Your Honor, if you'll recall, this issue first came to the court's attention on a motion for third party complaint filed by the defendants here in Clinton County. We objected to that motion, basically saying that the venue statutes don't allow for this case to be tried in the same county, and the apportionment statute doesn't give us any authority to force them, Barron County defendants, to Clinton County unless venue is waived. And so, Your Honor, I think correctly stated, okay, well, let's let them file the third party complaint, and then the Barron County defendants can either waive venue or object, which they did. Then an agreed order was tendered on, I think on the morning of the hearing on the motions to dismiss, basically saying we're going to voluntarily dismiss the complaints we just filed, but we still want the court to rule that we get an apportionment instruction because we filed. And so we were not a party to that agreed order. First of all, that's my first objection. And second of all, it's, I believe, inconsistent with what my understanding of the court's prior ruling was that, I don't know if you explicitly stated that venue was not proper, but I think implied in your ruling was that we'll let them file the third party complaints and then let the Barron County defendants either consent to venue or object. And so we don't have any objection to the Clinton County defendants voluntarily dismissing their complaints or the Barron County defendants being dismissed. But what we do object to any ruling that the filing of a third party complaint somehow enables them to get an apportionment instruction in this case against defendants who the plaintiffs could not have
How would
sued.
an apportionment happen if they weren't parties?
I think the law in Kentucky is clear, Your Honor, that it can't. I think what they would like.
I'm having trouble with that as far as what the proof would be.
That probably have to be for the third party plaintiff, I guess. I don't know if you can hear it.
Can you hear what's going on there, brother?
Sorry, I'm having a little bit of trouble hearing them when they're not behind the mic there.
He asked how apportionment would look in this setting, and I said that's probably a question for the third party plaintiff in this matter.
Or how the proof would come in.
Yeah, how the proof would come in on that.
How proof would come in. Yeah, I mean, we envision just having an apportionment instruction for the third party defendants, for each of the third party defendants. As
Well, would you have to talk about the breach by the third party defendants? How would the jury know? Maybe I don't understand this. I think I understand.
Sure. I mean, yeah, we would have to.
Don't worry about looking at us. Worry about talking into the microphone. Where's the microphone?
Well, it's over here to my right. So I think that, yeah, we would have to put on proof to show, obviously, that the third party defendants had some sort of liability in the case. Yeah.
Now, what's happened in Barron Circuit Court in this case?
They just set a trial date for us, last week or something?
Yeah,
We got a trial date.
It's
set.
been last month. We set a trial date over there.
Yeah.
So we'll start plugging along on expert discovery, moving towards that trial date, which I believe is February or March of 2025 or 2026, sorry.
That's right. This case is procedurally farther along, Your Honor. Expert proof's been taken. I would have already moved to get a trial on the books here in your court had it not been for this issue.
There's just something basically wrong about having to try this thing twice, in my opinion. Okay, the medical center at Albany technically is its own, I mean, it is its own entity, but it's owned by the medical center Bowling Green, is that right?
Correct.
Bowling Green.
It's an entity of the Naris.
So you got T.J. Sampson's doctors versus Bowling Green Medical Center's doctors who are operating through the local entity here is basically what you got. And Medical Center Bowling Green doing business with Clinton County doesn't want to take the case to Glasgow, right? Is that it? You don't want to take the case to Glasgow?
That, I'm not sure about Mr. Whitmer, but I can tell you from the medical center standpoint, that's correct.
What was the question? I'm sorry, we didn't want to take the case to Glasgow.
Yeah, who do you represent?
So we represent VIP Imaging and Dr. Babin and Dr. Ladson.
Yeah, and the Medical Center at Albany. The Medical Center at Albany group.
They don't, we do, Your Honor.
Yeah, yeah, they contracted out, but
Radiology,
yeah. But any kind of liability that the Medical Center at Albany has would be virtue of something amiss with the radiologist, correct?
Well, Your Honor, it's under a vicarious liability is why the medical center
Yeah.
is still in there. We've got a summary judgment motion that's still under submission with Your Honor. So from the medical center standpoint, you know, if we're entitled to summary judgment and your ruling is for summary judgment, that the radiologists would be the only ones remaining in the case for Clinton County.
And where are the radiologists located?
Their treatment was performed in Clinton County.
No, where are they located? Where do they live? Louisville.
Where do they live?
Where are their offices at? They might perform services here, but they probably do it online. You know, I doubt if they ever come to Albany. I don't know where they could find Albany.
Yeah,
Some people have trouble finding Albany.
Yeah, I believe VIP Imaging is in Jefferson County.
Okay, if I were to enter a summary judgment for Medical Center at Clinton County, then you would have the radiologists located there. The ones that would be left as the third-party plaintiffs, correct?
That's correct.
Okay, now who represents them? Okay, do you have any problem taking this to Barron County? If the Clinton County Medical Center is out of this. I mean, I'm gonna tell you what, you're trying the case one time. And you're exposing yourself to one jury. And you're exposing yourself, and I'm just supposing, I'm not trying to influence you. But you know, if I was any kind of plaintiff or or defendant, I would rather expose myself in a community the size of Glasgow than I would a community size of Albany. Just saying.
Well, I mean, Judge, I guess I'm not, I haven't really thought about that before.
Okay, I'm gonna give you this. I'm gonna enter summary judgment for the medical center at Clinton County, doing business as a medical center at Albany. Okay? And then you can have the next 10 days or so to file a motion to see if you object to venue over there. If he accepts venue over there, we got a deal. We're out of here, correct?
Not up to,
I
not
know,
up to us.
I know, but y'all don't care. So you could have your two radiologists try the case here if you want to as the defendants without the medical center of Albany involved in it. Or you could wait, if he waives the venue to go to Barron County, we got one trial, correct?
Correct. Candidly, Judge, the motion for a third-party complaint against the radiologist has not been filed in Barron County at this point. That's
It could be transferred over there, couldn't it?
It certainly could have.
That's what I'm talking about.
Okay,
I believe I can do that,
you absolutely.
you know.
Really, Your Honor, on behalf of TJ Sampson, all I care about is, I think we have agreement. They don't want us in this case. We don't want to be in this case, and they've agreed to let us out of this case. I just want to walk out of here today not being a part of all the fun down here, even though I enjoyed the drive to Albany today. But everybody's in agreement that these three defendants should be dismissed. And so I don't see any reason not to do that. And certainly you can transfer that case later, if you like, but I think everybody's in agreement. We ought to be out today.
The TJ Sampson Hospital ought to be out.
TJ Sampson Hospital and
TJ Health Partners LLC ought to be out.
yes, sir. And all the third-party defendants ought to be out.
We have two radiologists at Glasgow Radiology.
And I have a general surgeon in Glasgow.
Okay, they would be left in.
No, that would be out of this case.
I know, because they'd be left in over there.
Yeah.
All of us
In Barron County.
are, all of us are in Barron County in front of Judge Alexander.
We're all set for trial in Barron
I
County.
love Judge Alexander. I
So
want
do
to
I.
do something for him. Well, if you will reach an agreement to transfer your case over there on behalf of your third party plaintiffs, we're all right. How do you feel about that? Do you need to get back with him?
I would feel a little bit more comfortable getting back with you about that. And so 10 days to transfer it to Barron County, correct?
I'm gonna let all the medical centers and everybody out of here, okay? I can't let you out of here, but you can leave here with my blessing.
You're talking about the people from Barron County are gonna be let out? Is that what you're saying?
I'm gonna let everybody out of here.
Okay.
And again, Your Honor, I don't have any dog in that fight and I don't have an objection except to the extent that I don't want the order to somehow give them, they get to stay here and they get an apportionment instruction against the Barron County defendants, which is what the order they tendered.
Well,
says.
I'm not gonna let that happen.
Okay.
One of the bailiffs told me that, I don't know, I guess somebody told me I had one of my old law professors at U of L. That would be the Brandeis School. I've been to Lual, at least for a little while. He told me that sometimes you have to let them lay where Jesus flings them. Yeah. So what I'm saying is we can enter an order that does no prejudice to any party by my order here and let you fight it out over there in Glasgow. So that's what the order. I don't want anybody to seek any advantage, an apportionment instruction or anything else by my order. The plaintiff, okay with that portion of it?
I am, Your Honor.
Okay. So here's the deal. There are all sorts of statute limitations, questions, and other things here that you might very well not prevail on if I rule. Or you can get out of here voluntarily and let me transfer it over there to Barron County. So talk to your client and circulate an agreed order within 36 hours if you're interested in doing that, okay? Who's going to draw this order?
I can, Your Honor.
Okay, you draw the order.
Your Honor, do you need another summary judgment order, or was it tendered
You can tender it electronically, but I want it modified somewhat, okay, to make sure that you have your portion of the issue addressed in it. Let me make a finding, you know? You do want it in there, don't you?
Yes.
Okay.
That would be
then-
preferable.
Then you draft it that way. And I'll just say that I'm reserving my other motions on dismissing the third party plaintiffs. Things that he has remaining here. I'm reserving that, and I'll take a look at whether they want to voluntarily go to Glasgow or whether I take a look at whether they have a statute of limitation problem. Okay?
Just to make sure we're clear, we're talking about one order for all these issues.
Yeah.
And how long do they have to make the determination?
36 hours.
From,
Well, you can just leave that out, leave that 36 hours out. I'll take it under, I'm just telling him he's got 36 hours to tell me what he wants to do on it. If not, is there anything you want to argue on against this gentleman on the rest of his motions, the statute of limitations, those sort of things that anybody has a?
I mean, we pretty well briefed everything. It was a response filed. I think we supplemented with an unreported case that was pretty on point.
It wasn't.
That we practiced that.
I wish I could choose the cases I haven't had my unreported.
Don't we all?
Yeah.
I get it.
Yeah.
But I think things pretty well briefed.
Okay.
I mean, but my understanding is we're all getting out because.
Unless you want to stay, okay, everybody's getting out.
Right.
The only person that's still left in are the two radiologists.
Right.
That are third party plaintiffs, and they can decide whether they want me to determine their future on the motions that are pending, or whether by everyone's agreement, they transfer the case over to Barron County. Yet nobody has an objection to them going to Barron County, right?
No, sir.
So you understand what we're saying, counsel?
Yes, Judge, I do. I have 36 hours to discuss this with my client and get back and tender an agreed order with the plaintiff, correct?
What you can do at that juncture is you can submit an agreed order. Allowing me to transfer the over the change of venue and let them have this case. Okay?
And we'll send your blessing to Judge Alexander.
Oh, I love Judge Alexander. It's a different Supreme Court district, but I've got one county that I share with him in Monroe County. They saw a benefit to put it over in that, just near Bowling Green.
Right. Right.
Okay. Thank y'all very much.
Thank you.
Thank you,
Okay,
Judge.
what else do we have? Ms. Capps, what do you have here?
Judge, I've got a hearing with you at 3:00. I just got here a little early.
Henry Smith order, Your Honor, if we could get that.
Hey, thank you.
Smith is trying to go, just wait in the hall.
Let's go off the record.